Good morning, everyone. We're about to start. Motion to adopt today's agenda. There's a motion on the floor and has been seconded. Any discussions on the motion? All those in favor say aye. All those opposed say nay. The ayes have it. Motion carries. At this time, moving along to the agenda, we are joined this morning by the Chief Prosecutor, Mr. John Bradley. And we would like to welcome you to the podium to receive your public comments on our criminal justice reform bills that are on the agenda today. Thank you for joining us, Mr. Bradley. Would you like copies of the bills or?
Yes, that would help a lot.
Okay,
to
short
confirm.
recess, please.
All right.
Justice. And at this time, we will hear from Mr. John Bradley, the Chief Prosecutor, for his public comments on the criminal justice reform bills on the agenda. Mr. Bradley, you have the air.
Thank you very much. And I want to thank the committee for the invitation and the opportunity to comment on legislation. One of the things that I enjoyed the most about being a prosecutor in Texas was the participation that we had in the legislative process. I went to many sessions and discussed bills and always enjoyed working with that branch of government. For several years, I also served as general counsel on one of the Senate committees that did a lot of the criminal justice stuff, and it was such a different education to see how all of this happens from the inside of the legislative branch, and so I come here with a lot of appreciation for the difficulties that you face in trying to keep everyone happy with a piece of legislation when you're trying to actually accomplish something, and without just watering it down so that it doesn't actually do anything. Those requires a lot of diplomacy and delicate consideration. So I appreciate the opportunity to review these bills. I know that we have presented through the Attorney General comments on all of these bills, and I'll try not to repeat what's in there. I'm sure y'all are familiar with it. Is there a particular bill you want me to start with?
Sure. How about 22-7 is one that we have repeatedly been discussing, and we're still awaiting from the Department of Corrections Commissioner, but we would love to receive your input on that.
Good. That is a bill that I am familiar with. I was asked some questions about it through the Department of Corrections, and I know the lawyer who helped work on some of this language and has been pushing for it to be passed for the Department of Corrections. It's a very significant bill. It would help cut down on some of the issues that all of you, I'm sure, see repeatedly through the Department of Corrections, and that is the introduction of contraband into the prison. That can include all kinds of things. Obviously, drugs would be the most significant, but if you have spent any time in a prison environment and the various regulations that they have, prisoners are restricted quite a bit in what they can have and what they can do in ways that to a free person might seem rather strange and harsh, but those restrictions are the result of experience and finding out what you need to keep a safe environment in a prison and to avoid not only violence but damage and corruption within the prison. And the very big difficulty that CNMI faces is they don't have any criminal laws that penalize contraband within the prison. Now, if someone is caught with a drug that's listed in the Controlled Substances Code, like if they have methamphetamines, then of course we can prosecute that possession because it's a separate crime under the Controlled Substances Act. But the vast majority of problems that they face are not the kinds of things that are in the free world a crime to possess. The most obvious example that creates a lot of problems is cell phones. That is a way for a criminal to continue his criminal operations while in the prison. And we see, particularly in related to drug cases and other cases, that goes on. Another reason they don't want to use the phones there at the prison, which are available, is that those calls are recorded and can be monitored. So if the defendant is engaging in criminal activity, he doesn't want to use the phone that captures his very criminal activity. But there are a broad number of other things, simple things like cash, cigarettes. All of those things become items of exchange in a closed environment like a Department of Corrections. And if you don't control them and keep them from coming in, then you lose control of within the prison itself. And then the other real reason this is necessary is that while you can, maybe catch it and do some internal discipline, that doesn't really change behavior. It's the threat of a longer prison sentence that will actually change that behavior. In addition, it would make more of an impression upon the people who assist in bringing in the contraband. And that can be the inmates themselves, but unfortunately, it also often includes family members or, unfortunately, government employees, which can be DOC officers or DPS officers and others. And in the period of time that I've been here, I have seen all of those things arise during investigations. And we're somewhat restricted in how we can respond to those things because there isn't a statute that would make that activity a crime, either for the prisoner or for the person introducing. It would just be some sort of a violation of some personnel or disciplinary rules, which have relatively light consequences for that. The difficulty, of course, in coming up with a contraband law is defining contraband. It's easy enough to start with a list, and there's a very good list in here. But most laws also try to build in some flexibility because I'll tell you, inmates are creative. You tell them they can't have one thing, they'll move on to something else, or they will alter something to become something else so that it becomes dangerous. An example would be the case that we had in which the inmate had an electric toothbrush, which he then sharpened the tip of it so that it became essentially a shiv or shank that could be used to stab someone. And that was used in a case to stab into the head of the woman who was doing haircuts for inmates. And we had a somewhat difficult time trying to prosecute that as a felony. We ended up prosecuting it as a misdemeanor. We couldn't even successfully get the feds to prosecute that because they didn't have sufficient connection for that to be a federal offense. But we successfully did some prosecution of it, but it would have been a lot easier under this because it would be obvious contraband, because it would be altered to become so that it becomes something for a different and illegal purpose. And it's not like you can come up with a list of every single item that they have in jails. It more has to do is what did you do to alter it, and what was your intent when you did that. And I know that there has been some discussion that maybe that's too broad, maybe that's too vague. But what narrows it is not the fact that it can be anything. It's the fact that it has to be something that's used for an illegal purpose. And that's what narrows it down. I mean, you can't just prosecute someone because they have a pencil. You prosecute them because in the manner that they altered the pencil or the way that they used it in the circumstances that occurred. And that way you keep this from being something where you're just prosecuting someone for whatever happens to be in their cell. And it really does have to do with the narrowing of purposes so that they are only for things that are safe and as they were intended to be designed. So that's the comments that I have on that. This would be a major step forward. And, what I always suggest to the legislature is we need to get a bill in place to learn more about how it applies. The legislature can always come back and fine-tune something. If something is missing, if something you feel like is being applied too broadly, those are things that you can always revisit with additional language and amend it. But the bill as written now, I think, is a tremendous step forward, and our office certainly supports it and recommends its passage.
Thank you, Mr. Bradley. Can we hear your comments on House Bill 22-38 and 22-39? One moment. Recognize Representative Tina Sablon.
My apologies, Chair. I just had one quick clarifying question on House Bill 22-7 before we move on, if that's okay. Mr. Bradley, welcome. Good morning. Thank you for being here.
You're welcome.
On page 3 of House Bill 22-7, line 3, I wanted to ask you about, because that's where some of the criticism and the concern has been raised, is any authorized property that has been altered is so broad. And I wanted to ask you, if we could sufficiently narrow that in the way that you described, any authorized property that has been altered for an illicit purpose or language to that effect. Would you have any objection to that?
No, I when I read the comments that were criticizing that, I don't disagree with that. That's a pretty open-ended sentence.
Right.
And as I suggested, our purpose is to make sure that property is not altered so that it becomes a tool for something else, something illegal. So, any authorized property that has been altered for an unlawful purpose,
Okay.
would narrow that, because then the prosecutor would have to specify, okay, why is he doing that? If it has been altered so that he can try to open a door and escape, that's an obvious unlawful purpose. If it's been altered because it was broken and he's trying to fix it, that's not going to be a crime and not going to be an unlawful purpose.
Okay, thank you. And then similarly, on page 2, there were questions also about defining contraband as money, and and then it goes on alcoholic beverages, tobacco, and related products. Is it necessary to itemize those if we can just move right along to D and provide that any item or article that is not explicitly authorized by the Department of Corrections by regulation or statute would fall under this definition?
Either approach would be successful for our purposes. I would suggest, though, that the list of money, alcoholic beverages, and tobacco have become quite common for all lists of what contraband are in prison. All three of those things, for obvious reasons, contribute to a lack of safety in a prison.
Okay.
You don't want a means of exchange to be created inside of a prison, because then you have people who control others through that means of exchange. The addition of tobacco is a relatively new one. It was a really big deal in Texas when tobacco in prisons was prohibited, and everybody went, "Oh my goodness, the world's going to fall apart." And it didn't, and now they're smoke free, and it also means that they're not a means of exchange. So health is improved, and you reduce violence because you reduce that means of exchange. But whether that is in D through the regulations or in A through C, that's a policy choice. The one reason you might want to make it as a legislative policy choice is it's more permanent.
Okay.
If you have one DOC commissioner who wants to be able to smoke in the prison and another one who doesn't, these things might bounce back and forth. And by setting a consistent policy on those through the legislature, it may be easier to impose. But either process for the purpose of it would get that accomplished.
Okay, thank you. And I yield, Madam Chair.
Thank you, Rep. Sablon. Mr. Bradley, can we hear your comments on 22-38 and 22-39 for further clarification?
Sure. I will start with 22-38. This is a fairly simple bill. It does a very narrow thing. As a prosecutor, I have seen how we approach the investigation of cases involving children change tremendously over the last 25 and 30 years. And one of the single biggest steps forward was the recognition that interviewing or talking to a child should be treated differently than talking to an adult for a couple of reasons. One, children have different attention spans, have different vocabularies, have different educational levels than your average adult does. And so someone needs to recognize that and accommodate that in the course of talking to a child. Secondly, children should not be subjected to the repetition that occurs in the criminal justice process in giving statements. You know, if you are in the criminal justice process, you might initially talk to a police officer at the crime scene. Then you might have to go back down to the police station to do a more detailed written statement. Then you might get a phone call from the prosecutor to ask about the case. And then you might go to court and testify at a preliminary hearing. And then you might later on go to court and testify at a trial. And there can be more times than that you talk. And for a child, that can be exhausting. So what was created was a child's forensic interview. And that included two components. One was a person who is trained in how to talk to a child in a way that gathers neutral information without leading questions. And then second, it's recorded. The best way to have it recorded is both sound and sight through video. And then that recording becomes essentially the investigative report of what that child saw and reported to the police. And we're very fortunate here in CNMI. The Department of Youth Services has done a great job of training forensic interviewers, of setting up a child-friendly room, and of providing space and access for the various people involved in that to be present and listen while a single forensic interviewer talks to that person and records that statement. That recording then becomes a confidential piece of information, because obviously a child's talking about very, very detailed physical abuse or sexual abuse is very private. A copy of that is kept with DYS, but is provided then to DPS and is provided to the prosecutor. And we very much embrace that. We are able to then listen to that recording without bothering that child with immediately. We can, if it's got the proper details, make decisions about charging, and then go ahead and make that charging decision. All right. This is where this new bill would come into play. Once the case is charged, the defense is entitled to discovery of information. Now, the timing of when that discovery under statutes can be different, but I will tell you that we have adopted an open file policy at the Attorney General's office. And once a person is arraigned, that means they're facing the formal charge. It is our policy to instruct our staff to immediately collect all of the information that we have and to share it with the defense attorney so that they can have access to it, read it, learn it, and make decisions about the case, regardless of what the rules say about when we have to do those things. We try to do it as the earliest possible stage. For most of that information, like the offense reports, the criminal histories, and maybe even some of the adult statements, we just make a copy of those things. Usually we scan them, and we have been very successful in delivering that stuff electronically. We'll email it to the defense attorney, and they understand that this stuff is confidential, that it can't be shared outside of their office, and is not accessible to the public, at least at the point while the case is still pending. There's a couple of areas, though, where we're not comfortable doing that. While we want to share the information, we don't want to provide copies, because then we lose control and it could perhaps go out to the rest of the world. And one of the areas is this recording, this disc typically, that is of the interview of the child. And a lot of states, a lot of jurisdictions have faced the same problem. The problem has arisen because we have a time when things can be shared instantly worldwide. You know, I have seen cases here in which I haven't yet gotten a call from an investigative officer, and I can watch the crime being committed on Facebook because someone was there and had their phone and then posted it. We've actually had cases in which defendants have streamed their crime live on Facebook. So people's understanding of electronics and sharing and privacy have changed quite a bit. This bill would provide some protection for that child's recording for the period of time that they're facing, this criminal case. And all it would simply do is say that we don't give copies out. They can come and arrange in our office, and that's what we do now. So we set up a computer, we put it on the TV or a laptop, and they can come and watch it, and that's their discovery. They can watch it as many times as they want. They can take their notes. You know, if they have an expert who needs to see it, we will also arrange for that expert to be able to view it too. We just don't want to release it as a copy because then it becomes out into the internet world. And I think that the bill also says the same thing about child pornography. You know, we don't want, by the very prosecution of the crime, to share to the world the very images that we're trying to prosecute. And so those would do that. Same thing for child abuse. So that's the simple approach to this. A number of jurisdictions have already been doing this for a number of years. The courts have litigated this and found it to be an acceptable way to provide discovery. And the court is instructed to follow it that way. So this bill essentially protects the privacy and the confidentiality of a child's words.
I just have one question. You mentioned about experts and that you would still allow the expert to be able to view these videos or recordings. What if the expert, because there are hardly any experts here in the CNMI, so what if the expert is coming from off island and is unable to be physically here to review these recordings? How would you arrange that, and would that not be impeding on the defense's ability to make decisions on the case?
Technology is wonderful. We can play that digital information for that expert anywhere he is, but we just don't want him to record it, to have a recording of it, so that we lose the ability to control where it is. I think COVID has proven to us that we can hold meetings anywhere and see and read anything at any time now. The Zoom app is very good about that. I've already participated in a number of trainings where I'm here and they're off in Las Vegas and we're watching videos and we're discussing issues, all of which can be done electronically now. So I don't have any problem believing that can be taken care of.
Thank you. So clarified. You may proceed.
The other bill is 2239. And this one is just as powerful a help for children, but it's a little more legalistic. So bear with me, and I'm gonna give you unfortunately a short law school lecture on what it attempts to do. When children are physically abused or sexually abused, we have found through experience and through research that children very much delay reporting it to someone. Unfortunately, that's often because the perpetrator is someone within their family, someone within their close range, or maybe a teacher. And so it's a person of authority, and it confuses them as to who they should report it to if it even occurs to them that this is something that's wrong. If it starts happening young enough, they may think this is normal behavior. So the experience is that not only do children tend to delay reporting that crime, when they do report it, it's usually to an individual that is somehow connected to them and they feel safe with. The most common thing that we see is a child saying something to a teacher. Maybe one day they stayed behind in class and they didn't want to go home, and the teacher asked, is there something wrong? Shouldn't you be going home? I don't want to go home because my daddy keeps touching me. Okay, that statement is what we call an outcry statement. And it is the first time that a child reports physical or sexual abuse to an individual. And that can become a very important moment, because later on, after the investigation has happened and someone else interviewed the child, and the child has to go to court and to testify, the most common thing that the defense does is say, well, why should we believe this child? They waited 5 years to say something about this. Isn't it true that they've never said anything about it to anyone else? And they just said this because they got in trouble at home. And often we now want to respond, and we want to make it clear to the judge or the jury the context of how this came out. But it faces an objection. What's the objection if someone comes in to testify that this child told them what happened? It's the most common objection you hear in court, hearsay. And so there's a rule of evidence that says that we tend not to want to have testimony that is merely the repetition of a statement made outside of court. Let the person who made the statement come in and testify to that, and then I can cross-examine them under the Sixth Amendment. This is an exception to that rule. This would create an exception that would allow the testimony of the first person who hears the outcry of the child. And there are a number of important protective measures in this. It only applies to the statement about the offense. It's not about the rest of her life or anything else she feels about. It has to be made to a person 18 years of age or older. So it's to an adult. And we give notice to the other side before we're able to use to that, so they are aware of it beforehand. We give some description of what the statement would be. In addition, the judge holds a pretrial hearing, and he makes a determination based on the circumstances whether or not this was a reliable statement. So there's not just, some garbage that got stated somewhere early on. And finally, one of the most protective things that's in this, that by law doesn't even have to be in here, is that the child will be available to testify. So if you really have a problem with what that child's outcry was, and you're doubting what this adult person is saying, here's the child. Cross-examine the child on that. Ask the child, did you actually say that, 5 years afterwards to your teacher? Yes, I did. Or no, I didn't. So those protections make sure that the defendant's right to cross-examine the witness on the information are protected. This issue has been previously taken all the way to the United States Supreme Court, and in a very significant case back in 2015, the court found that this was an acceptable exception to the hearsay rule. We've gone beyond what that Supreme Court decision said. In the Supreme Court decision, you didn't even have to have the child testify or be cross-examined. They found that it was admissible as an outcry statement. Here, we provide the additional protection I think it's important that the child be available to testify if you're going to use the words out of that child's mouth to convict someone. This is a very significant issue here in CNMI. In virtually every child abuse, sex abuse case where a child is the victim, this issue comes up. And the courts here do not have a rule currently where they feel comfortable making this admissible. And this statute would set up very clear standards for the court to follow in doing that. It would protect the child by giving the child basically someone else to help support what that child is talking about, what they did, and in helping educate the jury of the context of how all of this began. So that's the simple approach to that. That's your hearsay rule for today. And we appreciate it. And the Attorney General's office definitely supports this bill and would ask for your passage of it.
Thank you. Recognize Representative Tina Sablon.
Thank you, Madam Chair. I wanted to clarify on page 2, Mr. Bradley. Well, one, this bill also would apply to statements that are relevant to crimes committed against persons with disabilities, right? So
yes,
whether they're children or not, but if they're a person with a disability, this would.
That's to capture the population of people who have mental health issues and therefore might not be able to express themselves as clearly. So, and we've had a number of cases like that where while they weren't a child, their mind was as if a child, and this would allow that to come in.
Is there a definition anywhere in the law, though, that would provide that clarification?
Yeah, yes, there is a definition of disability. It is in the code, and I'll get that and send it to you.
Okay, and then going down to subsection A2, should we then insert the words "or a person with a disability"? So allegedly committed by the defendant against the child or person with a disability who is a victim of the offense, or another child 16 years of age or younger, or another person with a disability? Is that?
You're talking about lines 7 through 10?
No, I'm talking about lines 19 through 21 on page 2.
Page 2, 19 through 21. Oh yes, I missed that in the because that's for punishment purposes.
Right.
So yes, that should be added in there to make it consistent with the others. Thank you.
Okay. Okay, and then I guess that's it for my questions on this bill. But you'll get to us the site. Oh, actually, no, you do define it on page 4.
Is it on there?
A person with a disability means a person 17 years of age or older. Okay.
Okay.
Yeah. All right. Thank you. So I think we'll have to insert that as an amendment to clarify to include the person with a disability language in lines 19 through 21.
That would help if we're using this for punishment evidence.
Yeah. Okay. Thank you. I yield.
Thank you, Representative Sablon. Would you like to comment on any further criminal justice reform bills, particularly House Bill? There's 3 more in the committee that they would like to dispose of, not necessarily today, but House Bill 2235 is to add a provision to prohibit convicted felons from possessing firearms or ammunition. There's 22-36 to provide better clarity for trial courts to impose sentences. And then there's one more, 22-37, which is to amend Title VI, Division 3, Chapter 2 of the Commonwealth Code by establishing a penalty provision for criminal defendants who fail to appear in court on their scheduled date.
I'll start with House Bill 22-35. This would make it illegal for a felon to possess a weapon. And most people who I mention this to are surprised to hear that we don't have a statute that already does this. And I think what happened is that there was a previous gun bill. It was held unconstitutional, and so the legislature amended it with a new gun bill. That new gun bill did not have the crime of possession of a firearm by a felon. And that's really created a big gap. I have had probably as many as 10 cases while I've been prosecuting here that we could not pursue, where a convicted felon had a gun and often committed a crime with it. It really came to my attention when we were dealing with the Castro case. That's where the individual essentially traded for drugs for a gun with a DOC officer, and then ended up using that gun to kidnap a girlfriend and then hold her hostage, and then ultimately in a shootout with police, both of them died. Now, he was a convicted felon and should not have had any kind of a gun anywhere. But if he had lived, I could not have prosecuted him for possession of that firearm under CNMI law, because it didn't exist as a statute. And I've had similar circumstances with guns come up repeatedly. The only option I've had is to try and seek assistance from the federal prosecutors, because they do have a federal gun law. I have not yet been successful in having such a case prosecuted. It's a very difficult process sometimes to get the proper evidence and get all of that screening done. I would be surprised if there is a jurisdiction, a state in the United States that doesn't have a felon in possession of a firearm crime. It's a very common crime. It's a good way to capture your most serious bad guys, because you've got a guy with a felony conviction and with a gun. And those are typically bad combinations. This bill would fix that by making it a crime for a person to have a gun if they're a convicted felon. It also makes it a crime to have a gun if you have been convicted of an offense that involved domestic violence. And the only reason that I included that in there is because it's already, that's a crime under federal law. If you're convicted of an assaultive offense, and it involves domestic violence, then you can't have a gun. That's in the federal statute. And so it seemed important to be consistent. We have a very strong domestic violence law here, that we make it consistent with that. Now, I have seen comments, and I don't necessarily disagree with them, that the phraseology that we have in here says any crime involving domestic violence would disqualify you from having a gun. That could certainly be narrowed in a number of ways, because there are some fairly low-level property crimes that might be described as domestic violence, and you might not want to necessarily prohibit a gun. But if it is assaultive behavior, so if it's assault and battery, and I noticed that the language has been added to this, that it is any crime involving domestic violence punishable by imprisonment. And that would certainly elevate it, but you can narrow it even further if you want and just specify assault and battery, but just assault and battery is the one that we most commonly have. Disturbing the peace could fit, but again, that I would agree is a much broader crime that might not involve the kind of violence that you want to have to disqualify the legislature makes with that.
Recognized Representative Tina Sablon.
Thank you, Madam Chair. So at our previous meeting discussing this bill, we looked at different ways to narrow down the types of crimes involving domestic violence as defined in, I'm sorry, Counsel, could you just pull that up to the citation Yeah. So the meaning assigned by 6 CMC section 1461A1, it's a whole laundry list of different
Yes.
crimes involving domestic violence. So if we were to narrow it to assault and battery crimes involving domestic violence, will we do that in subsection A or subsection B? Or could we just eliminate subsection B and
You're right. You could eliminate, well,
just any crime, any assault and battery crime involving domestic violence as defined by 6 CMC section 1461?
that would
Right.
narrow it substantially to that specific one.
Okay.
And that would actually make it much more consistent with the federal law.
Okay.
So
Okay.
it probably wouldn't be any broader than the federal law if you took that approach,
Okay.
which I would love to just add felons. So,
Yeah.
yeah, this
right.
area is just one of policy, and y'all are the ones that need to decide what level of public safety that you want for this.
Okay. So, Council, does that make sense? And Chair, for the amendment, so to strike out B and then insert in line 17 any assault and battery crime involving domestic violence as defined by 6 CMC section 1461A1. Would that suffice as an amendment?
It wouldn't, but you could. As you know, it needs to be in writing, and we need to.
No, right. I'm not proposing that we amend it right here this minute,
Yeah.
but would that address the issues that we were discussing?
So to clarify, we're gonna take the replace the word crime with something more specific and add a assaultive element.
Any
to it.
assault and battery crime involving domestic violence as defined by 6 CMC section 1461. A1.
Yeah, I'll verify that assault
Okay.
and battery crime would be the proper phraseology. But
Okay.
if
Yeah.
we're trying to take it from general crime to assault and battery, where there's a violence component or a threat of violence component,
Mhm.
then
Well, a domestic violence crime involving assault is what we're trying to do.
right, because
Right.
Yeah, but you got to be careful because you have to say assault and battery. Assault and battery under the CNMI penal code is where there's actual physical contact.
Okay.
Assault is just a threat.
Okay.
The most common charge for domestic violence is assault and battery.
Okay.
And that's the one that matches best with what the federal statute looks at.
right. So while we're talking about it at the committee level, so would you be opposed to, for instance, a DTP being considered a trigger for this?
I think a DTP would be a very broad addition to this. I personally am not opposed to that, but I think if you're looking at the bigger picture of gun rights versus, what kind of crime is going to take your gun right away, I think that's going to raise more red flags than it's probably worth.
And it did raise red flags
Yeah.
with the public defender and with some of the members here too.
I think you would also dampen the ability to sometimes negotiate plea bargains, because then the defendant's going to say, well, I would have taken a DTP, but now you're going to take my gun away too. It's this constant balance between all of these things. And so my preference is that you leave us options. And I don't have a problem with it being narrowed to assault and battery. That's the most serious of the crimes that, in my mind, should trigger a no-gun rule.
Okay.
If the legislature later on finds out that we've got a lot of people with DTPs running around in guns and there's problems, you can always come back and amend it and broaden it. But
Yeah.
I don't see that problem right now.
I just wanted to see where you're coming from. What about then just the plain old assault? Which is one
plain
level.
old assault is it could be somebody screaming at someone else, "I'm going to kill you." And when you're drunk and you say that, you get arrested and you go spend the night in jail. But 90% of the time, that's not an ongoing threat for which I need to take away your gun for the rest of your life. I mean, those are policy decisions. You can disagree and say, no, I want to take his gun away every time. But from my perspective as a prosecutor experiencing that, it's just a night of drunkenness and anger.
Thanks.
Not to minimize it, but to put it in context.
Thank you, Mr. Bradley. Tough decisions ahead for this committee.
Well, they are tough decisions, but that's what y'all do. Y'all draw these lines, and I guess my point would be we have no line right now. So I'm happy if a line gets moved at all.
I agree. We do need this bill since it was inadvertently or for some reason was taken out from the amended statute. So
Yeah.
we will take all your comments into consideration.
Thank you.
Was there anything else on the?
The other one that I would
37.
comment on is 2237, that has to do with failure to appear. If in the time that I have been here and the time that I spent in the court watching judges call defendants' names, not a day goes by that on a docket someone is failing to appear. The disrespect by criminal defendants who have been arrested or have been cited or who have been given summons to appear in court in ignoring that judge's requirement that they appear in court and deal with their case is extraordinary. Now, some of that is the result of them not being informed or illnesses or genuine transportation problems. But those people shortly show up in court or have an attorney that makes an explanation for them. But there is a vast majority that just simply ignores the court. And one of the reasons that I think that's become a growing problem here in CNMI is because there's very little consequence for it. Most of the time, the judge will say, well, I'll issue a bench warrant and I'll require them to post a bail. But every time that person appears, he quashes that warrant and they're not required to post a bail and they're told to just keep showing up. There's no consequence. Sometimes that disappearance happens for months, sometimes for years, and it damages our ability to prosecute cases. Witnesses are lost, restitution is not collected, and there's no consequence at all for the defendant, except the positive consequence of not being in court and not having his case prosecuted. This bill would do what every other jurisdiction does, and that is establish that it is a crime to intentionally not come to court when you've been given notice to do so. And it sets out two different punishment ranges depending upon the seriousness of the charge that you were facing. That's all it does. And I would ask that the committee seriously consider this as a way to move forward in getting the courts back into order and making people appear more regularly.
Thank you. One question. The failure to appear, though, wouldn't it already be called? Wouldn't it already be punishable under contempt charges?
I think in theory, yes. It would depend upon the circumstances because contempt is a violation of a court order. So it would depend upon whether the defendant received and disobeyed a specific court order. So in theory, yes. In practice, that's a very difficult thing to prosecute, and it ultimately becomes a misdemeanor. So let's say you're charged with robbery and you're facing, 10 years in prison. But if you fail to appear and you run off, you get what? A misdemeanor contempt? That's not much incentive to show up on your felony case. In addition, I don't think that the contempt really identifies the crime. The crime is that you failed to appear in court. And while contempt is a form of that, this is a more specific way of getting at it. So the misdemeanor approach doesn't work. I'm not aware of a single criminal contempt that's ever been filed here for failure to appear. And maybe that's something we could try, but I'm not sure the judges want to start seeing a bunch of contempt charges.
Recognize Representative Tina Sablon.
Yes, I had a question about the punishment. So on page 2, starting at line 19, an offense is punishable by up to 5 years confinement, a fine of up to $5,000 or both. If the offense for which the actor's appearance was required is punishable by more than 1 year confinement. Is that a typical punishment in other jurisdictions for confinement to be up to 5 years and possibly longer than the crime that they initially failed to appear for?
The quick answer is yes, that is consistent with what other jurisdictions do.
Mm-hmm.
The language is different because of how CNMI defines punishments throughout the code that we have. Most jurisdictions define the punishment for a crime as either a misdemeanor or a felony. And within a misdemeanor, they might have like a class A and class B and a couple of different levels. And in a felony, they might have first degree, second degree, third degree. The CNMI code has never adopted that modern method. And when you pass a crime, you just simply define a punishment range that goes with it.
Right.
The courts recognize that any punishment that is up to 1 year is typically recognized as a misdemeanor.
Right.
Any punishment that is beyond that is typically recognized as a felony. And so that was our awkward way of trying to distinguish between the misdemeanor and the felony.
Mm-hmm.
So subsection C makes it essentially a misdemeanor punishment up to 1 year and up to $1,000 fine. And then it goes up if it's a felony offense for subsection D.
So it would be, so failure to appear would be prosecuted as a felony if the actor was charged with a felony.
Exactly. That's exactly right.
Huh.
And
Okay.
and then the numbers that the legislature assigns to punishments in the felonies is all over the map. I mean, I've seen it as up to 8 years, up to 5 years, up to 10 years, up to 30 years. There's not a specific scale that the legislature has seemingly adopted and applied consistently throughout the code. So I just did it as if it's over a year, it's a felony.
Right.
I mean, you could certainly create other subcategories if you wanted,
Mm-hmm.
depending upon the seriousness. That was just my approach to that at that point.
Okay. Thank you.
And maybe
Thank you,
legislature.
Representative Sablon. Short recess, please. Thank you, everybody. Everybody, we're back from recess, and at this time, we will go on recess again for the lunch hour, and we will be back at 1:30 this afternoon. Thank you.